Judge, on this case, I filed a motion for entry of judgment, Your Honor. We just need to get an order signed, Judge. We've already had a trial on it. I presented evidence. I submitted two proposed orders. Um, Mr. Kane, Judge, all the times we've been coming, he's never filed one answer. At least I've never seen one. I've never been served with anything from him. So at this point, Judge, I'm just entitled to judgment as a matter of law. He hasn't filed anything. He never filed any pleadings. And so we've had a hearing on this. I submitted two proposed orders. The first one is just to make the temporary orders final and just bring finality to this case. And the second order I submitted was one where I believe that Mr. King was making in excess of the guidelines, which would make his child support 1,610 according to my calculations. And the other one was just to make the temporary orders final at 880, Judge. So we just wanted to see if you would just sign one or the other and just
Is court hearing main ek complicated child support case discuss ho raha the jahan judge ko decide karna the ku ek father ko apni bakche kaliya kidney financial support deni chahi. Case main mother ka lawyer any court esi request ki could judge final order sign cardine. Kyunki trial already ho chukada or evidence be present kia ja chukada. Lawyer ka kana the co-father any kabi properly jawab illegal documents file nahi kai, or is waja esi law kumutabik decision dia ja sakta hai. Unhone do possible orders judge ko samni rake. Ek main child support amount $880 were kagaya the Joe Pelly temporary order the Jap Dusser option main amount $1,610 tack increase karn key request ki gayuti. Lawyer any argument dia ko trial ko doran Joe financial records or bank statements samnie ans lagda hai ko father key earning capacity, zayada hai. Unhonek bank transaction ka zikrbi kia jahan $450,000 ka transfer record hua the jisa lawyer any income ka evidence bataya or kaha ka agar ec income mana jada child support guidelines kumutabik payment ka amount coffee zayada hosakta hai.
Let me get a response from Mr. Kane, and then I have questions for each. Mr. Kane, response?
I did submit documentation and the Thomas Reuter stuff. That's where I was told to submit anything.
All right. So these are the questions I have. I'll ask Mr. Cantu first, and then I'll follow up with the questions for Mr. Kane. Mr. Cantu, the court recalls multiple hearings and a lot of information.
Yes, sir.
This case wasn't straightforward, right? I mean, usually 99 times out of 100, people submit their black and white financial information, and the court assesses child support based on the calculation as required by law. In this situation, Mr. Kane's finances aren't as clear-cut as in many other cases. So the parties agreed to submit documentation that allowed the court to assess what the correct calculation of child support should be, if any should be modified. In that interim, or I should say thereafter, the parties did file information. The court received, reviewed, and considered all of that information, and then the court issued an order requesting additional information. I guess let me ask this question to both, and then we'll take it from there. Based on that court order, Mr. Cantu, what information was provided that allows the court to make that assessment?
Judge, to respond to that, Judge, because the discovery period had closed, I was no longer able to obtain any other information from Mr. King. He did provide to me all the information that we produced at trial, as far as tax returns, everything that he provided, bank statements that I submitted into evidence was what the court at the beginning had based its temporary ruling to make to increase the child support. After we had the trial and I submitted everything that I could, I no longer was able to get anything other than what I submitted as evidence there. So the discovery period had closed. I couldn't serve with anything anymore. So I just wasn't able to get anything else for you, Judge.
Well, and that's a perfectly valid and honest answer, and I certainly appreciate that. So then, before I follow up with that, let me get Mr. Kane's response. And I think I sent the order to both Mr. Kane. The information requested by the court, was that information provided to the court?
Yes, sir.
All right. And my follow-up question then, Mr. Cantu, then based on the information that you submitted and based on the information, evidence, and testimony provided to the court, what is Ms. Medellin's request, your client's request, and how is it supported by the information in the record?
So, again, he hasn't, I understand what he's saying, that he might have, I guess, produced it. I don't even know how he did it because I wasn't served with anything he produced. What I will respond to the court is I'll say, look, Judge, based on what I have to work with, the court did make a finding that there was enough there to at least raise the child support, to 880. It was 500 and something. The court raised it to 880, which we're okay with that. However, on trial, when it came to trial, we were here for about 6 hours. Based on what I presented, based on just one withdrawal that Mr. King made, which was in the evidence, which showed there was one withdrawal that he made, which converted into income of 450,000. He has the potential and earning capacity where that would put him over the guidelines, and then that would put his child support, according to what I have, at 1,610 a month. We would ask that the court, based on what we've submitted, what was presented at that trial, to increase it to that amount. If the court does not believe it can, then I would just request that based on the findings the court made at the temporary orders hearing, just to make that order final and leave it at 880. I submitted 2 proposed orders, and the court can sign one or the other. And so,
And that was the court's final question. The difference between the first proposed and the second proposed order is?
One order is at 1610 and the other is at 880.
Oh, I understand.
Yes.
Mr. Kane, court yields the floor to you. What response, if any, would you like to make?
So Mr. Cantu said that the 450,000 was income, and it wasn't. And I submitted the documentation showing that that 450,000 went from one bank to another bank to pay payroll that we had at the time. And then we lost that job and went into bankruptcy and still going through that as well. But I submitted that documentation showing that. I submitted too on the calculations. I'm so far behind on everything now. Everything I get, we had a company that we did government contracts. So anything I get is going to them because of losing that job and going through the bankruptcy. I'm actually going through a divorce as well, and I submitted all that documentation for this hearing.
You're going through a divorce and you submitted that documentation?
Correct.
How would that be relevant to this proceeding?
Because I've got child support that they temporarily ordered, which is what you had done based on Mr. Cantu's statements and mine. You said temporarily we would set it at 880.
Right.
And we submitted the rest of the documentation supporting, I guess you would say, my side versus his side of.
Judge any donosides ko dionse suna or kaha ku aam torpar ace case's main financial information clear hodi high, J's tax returns or salary documents, just court easily calculation carlita high. Lekana's case, main finances utni simple nahida, is liya judge any peli be additional documents, mangway the takasol financial situation same j. Father any apni taraf se jawab deet hu kaha kajo $450,000 ka transfer dikaya jaraha hiwo asol, main income nahida. Unka kana the ko wo paisa, surf ek bank account se disser bank account main transfer kia gaya the top company ko employees ki payroll pay ki jasake. Unhon bataya ku un key company government contracts parcom cardi t, like an ek important project kadam, hon ku bad business ko nuxin hua, or company bankruptcy process, main chali gai. ISI waja esi unki financial condition coffee karab ho chuki hai or wo khud bi mushkil esi apni expenses manage kar parahi hain.
What child support should be set at.
So
I'm-
respond to Mr. Cantu. Mr. Cantu says to the court that the court has sufficient information evidence in the record to set child support based on those transfers at $1,610. He says, and even if the court doesn't deem that as income, that there is sufficient information to set it at 880. Please respond to that.
There's not. I submitted all my tax returns and all of my bank statements. Mr. Cantu's saying that the $450,000 transfer is the justification for the 1610, and it's not, because it's not income. That $450,000 was transferred from one bank to another bank to pay out, and I submitted that as well in bank statements. And I've submitted all my tax returns, and we're showing a loss. Mr. Cantu said, well, how are you living if you're not making any money? And I said then, and sent the documentation in on loans.
Well, I understand that, but so to his point, let me see if I can try to quickly. I'm trying to get an answer to give you a fair shot at this hearing. His statement to the court is the court has and should set child support at $1,600. But even if Mr. Kane is right, and that isn't income under the law, then child support should at least at the minimum be set at $880. What is your response to that? And as a follow-up, if you disagree with that, what then do you believe the evidence shows child support should be set at?
So the 880 is what you had actually done a calculation on, based on Mr. Cantu saying that I had the potential to make an income to increase the child support. And that's where I submitted saying that, I'm doing everything I can now and can't pay it. And if that's the case, because I don't have any income that I keep, so to speak, minimum wage, and I honestly can't even afford that.
Final question, Mr. Kane. You said you were going through a divorce. In what state is that?
Wisconsin.
Now, as part of that family law proceeding or any other family law proceeding, are you responsible for the payment of child support to any other person other than the child in this case?
Yes, sir.
How many?
One.
So one child here and one child in the Wisconsin court?
Correct.
And in the Wisconsin court, and this isn't binding on the court, I'm just trying to get a picture of what is going on. In the Wisconsin court, are you ordered to pay child support?
Yes, sir. It's temporary order.
They find themselves in the same position we're in. So in that temporary order, what amount, if any, are you ordered to pay in child support?
That was set at, and I submitted that. I think it's $760 on temporary orders. And I don't have an attorney in this one either. They based that on the last year that we showed a profit, I guess you could say.
Well, and like I said, that whatever happens over there isn't binding on this court, other than the application of Texas law that says that you should get some credit. In other words, if you have a child here and one in this court, one in that court, but you start to see a pattern, Mr. Kane, about how the law universally applies everywhere and how the rules of evidence and the standards set tend to flow in the same direction. It sounds like the orders of this court, at least on a temporary basis, are pretty consistent, if not similar, with the Wisconsin court. What I'm trying to gauge is whether we are so far off, too high or too low. And it sounds like, based on the evidence that you submit, courts tend to reach very similar outcomes. Um,
The
I
court
tell
here,
you what, I'm going to take this, Mr. Cantu and Mr. Kane, as a kind of, and I'll construe this not only as a motion to enter, but I will reconsider to review and reevaluate based on Mr. Cantu's request to set, based on the evidence and testimony, at $1,610. And in the alternative, to be consistent with the court's previous finding at $880. And then I will temper that with Mr. Kane's request to set at minimum wage, and I will take into account all of the evidence testimony submitted to the court, and I will sign off on one of the orders. And if the findings of the court are different from the child support calculation in one of the orders, I'll scratch it out and write it in. Mr. Kane, is there any other
Father any court ko yeah. Bibataya ko abi ek or divorce case face kar rahi hanjo Wisconsin State main chal raha hai or wahan bian hiak or child kalia temporary child support pay karn ka order dia gaya hai. Unka kana the ku unki income of itni stable nahi rahi or jobi paisa milta hai wo loans or legal obligations ki waja esi kadam ho jada hai. Judge any unki batsan kar kaha ka court ka com surf evidence or law ka basis par decision lena hai. Judge any ya be explain kia ko axar log samaged hain ko agar parents ka pos 50 to 50 custody ho to child support automatically kadam ho jada hai like an assault main isa zarori nahi hoda. Courts har case ko alag circumstances kumutabik evaluate kardi hain or axar ek parent ko furby support pay karna padaha.
information, evidence, and testimony that the court should take into consideration?
I don't have any documentation. Our next court here in Wisconsin is mid-May.
Sure.
And at that point, the 880 was temporary orders until the final hearing. At that point, I actually won't pay any child support.
Under temporary orders in the Wisconsin court, you're set at $760. You think at final hearing, you'll be ordered to pay nothing.
Correct.
That's an impossible assessment for you to make, because no person can infer or definitively say what any court's going to do. That would be not right.
It's because we have 50-50 custody.
Many people think that, and I can't speak for any Wisconsin court or judge, but just because people get, I just did that. You just heard that. If you were paying attention, people said 50-50, and I said absolutely not. One person is paying child support. So it's very difficult for any person to definitively say, I know exactly what the court's going to do. And I won't speak for any court outside of this jurisdiction or outside of the state, but I can certainly speak on behalf of the judiciary, and it is impossible for any person to say, I know how any court's going to rule. But
I'm going off what the judge said in the, I guess, preliminary hearing for the temporary orders.
We can kind of forecast, but things change at the final hearing. I understand that. All right. Ms. Flores, I'm going to give the court its own orders due dates that I can review, and it'll be our own internal deadline. Orders due on
March 30th.
All right. Anything else put on the record on this case, Mr. Kane?
No, sir.
All right. Anything else on the record, Mr. Cantu?
Judge, if you would like, Your Honor, what I can do is both orders that I submitted for your consideration are identical in nature except for the child support amount. I can submit a blank one. I'll submit another one with a blank one, and if you are going to insert your own amount, then you can just write it in the blank.
Sure, and I'll tell you, and I'll disclose to you, Mr. Cantu and Mr. Kane, what the court is going to review. I'm going to see why the court should deviate from that 880, and what I need to know and assess is whether that 880 contemplates one child before the court and one child outside of the court. I don't know that I did that at temporary orders, but it sounds like if the court didn't do that, then it's very likely that that child support will be almost identical to the Wisconsin court, which shows you that there is consistency even across state boundaries. But that may change. I don't know until I assess. All right, Ms. Medellin, I need to give you an opportunity. Anything you want to say, or do you have any questions? Unmute your device, please.
Yes, good afternoon. The only questions that I have are how will his, how will he end up paying since he's already backed up close to 25,000? I mean, he has made no minimal payments.
How he pays is not generally the court's concern. If he doesn't pay, then you should talk to your lawyer about seeking remedies on behalf of your mutual son.
Well, the only thing is that when I talk to the Attorney General, they tell me that the only reason that they cannot do anything in behalf of my case is because it's not closed yet. And this case has been going on for, I think, more than a year. Or
Right.
I don't.
The court is going to sign an order on March the 30th. And you take that order, or they process it automatically. They're going to make all the calculations, and then they'll take it from there. If you have any questions, then you can either reach out to your lawyer or call the Attorney General's office to see where this is in the process.
Okay, I just want him to be held responsible. That's it.
Understood, Ms. Medellin. Mr. Kane, I wish you both well. More importantly, I wish your son all the best. Good luck tomorrow.
Okay, thank you.
Hearing ku en par judge any kaha ku wo sorry evidence or testimony dobara, review karenj or for final decision likit order key form main issue karenj. Judge any bataya ka agar zerarat huituwo proposed orders main amount change be kar sokt hain talk decision law or fax kumutabiko. Uski bad mother ko boln ka maukadia gaya jahan unhon apni concern express kika father already lagbag $25,000 kabak child support o kardi hain or unhon abtak koi meaningful payment nahiki. Judge any jawab dia ko agar payments nahi hodi to legal remedies available hodi hain or final order ko bad attorney general ka office be case ko process kar sakta hai. Hearing ku en par judge any dono parents ko good luck kaha or cause tor parung bakche kulia best wishes d. Kyunkia kir main court ka main focus bakche ki welfare or stability hodi hai.